My thanks to Peter, my thanks to everybody who's been part of the licensing office and the conference organizers. My thanks to all of you. A real treat, a real pleasure to be here with you and to share some ideas. So we have a tight schedule, so let me just get right into some substance and hope, Dave, that I leave enough time for you. I hope you can like make noise over there. And as the court historically even touched the issue of copyright, but that is changing, and that's a signal about how copyright has become a more prominent feature of the law and a more prominent feature of business and the daily lives of really many, many of us in this country and around the world. But look at these cases that have come from the Supreme Court. You know, we can think back because it's a case like this that maybe is just about the process of the law, but it's a case about the way we will be able to enforce our rights and the advice we need to give our clients about protecting their rights or investigating the rights of somebody who's bringing a claim against us. Are they properly situated to enforce that claim? Similarly, another case from this year from the U.S. Supreme Court, the question of if I win my infringement case and I ask the court under the statute for reimbursement of attorney's fees and costs, what can I get? And the Supreme Court clarified this too, narrowing the scope of what one can get. It basically summarized it like this, that if you win your case, you may still petition the court for the court order to reimburse your attorney's fees and costs. But let's get to what's not on the list of costs, and that is expert witness fees. I've done that, been there, and look forward to doing more. Expert witness work, I think, is very engaging and extremely important for many of these cases. But this case is raising the question, and in fact around the world. I deal a lot with their issues, and for decades, at the top of the list, keeps bubbling up to the top of the list, is the question of fair use. So these cases, I have to admit, capture my attention and indeed demonstrate something about the way the law really is changing, both in terms of how we're testing the meaning of the law in front of the courts, as well as testing the meaning of the law as applied to different types of media. The history of fair use begins with print, stays with print for much of its existence, but today we all know that we're able to use, create, transmit, manipulate, mash up, do a variety of things with different types of copyrighted works. And this is posing a fresh new challenge for the courts. So let's look at examples of what's not, what may be, and what is within the scope of fair use. So a couple of cases just to illustrate some of these trends. The so-called TVI's case, again, to grossly oversimplify, capturing a company for commercial purposes, capturing the recording of the news broadcasts from different sources, including the plaintiff, in this case, Fox News, and capturing that content and then licensing it to subscribers for their uses. So if you are putting together a business program, you want a clip of that news clip from, in this example, Fox News, TVIs could be a source for that. If you are another TV station, you need that clip, TVIs can be a source for that. And so to sum it up, what the Court of Appeals ruled in this case is that that kind of commercial uses on a large scale is not within fair use. Now, this case, the parties in arguing fair use were largely springboarding off of a couple of earlier cases involving the large-scale digitization, capturing, and uses of books in particular. The Google Books case is the most prominent of these decisions. And that it's capturing that content and then using it in new ways that don't necessarily match the ways that the original copyright owner, Fox News, for example, was using that content. And so this feeds into the question of whether or not this is a transformative use. And in those examples, like Google Books, the court found transformative because it truly was using the digital version of the book, the digitized version of the book, to use it for indexing and for accessibility, people with disabilities, and so on. But in this case, the court really saw this as commercial use that is potentially competitive with the original Fox News purpose. So the court found no fair use in this instance. Another Court of Appeals case that's been going up and down the court system for more than a decade, and it's still in the court system. We may even have a decision, who knows, maybe today, the next decision in this case. But this is the so-called Georgia State case, and it's the case in the 11th Circuit, and the answer is it maybe is fair use. And the question of whether something is fair use in this context depends on a number of different factual variables. And in this case, the issue is the digitization of portions of books to make those available as reading for students enrolled in courses at, in this case, Georgia State University. Now, and they've never been law. So that's something we need to watch for as well as this case proceeds through the court system. By contrast, here's what is fair use. The use of a photograph of the greatly acclaimed singer Prince, but the rights of the photograph with the photographer, and Andy Warhol using that photograph to create this work of art. Now, we've all probably seen Andy Warhol works of many types of many subject areas where there is the use of existing photographs, typically of well-known people, being, I'm going to use a key word here, transformed into this work of art. And the court found that indeed of the three factors that seem to even make a difference to the court, this weighed in favor of fair use. Now, pausing briefly, there is a sequence of cases that are working through different courts that have arrived in the last year or more that deal with the question of fair use of photographs. And so there's an interesting development in more general terms about the application and the courts facing the need to decide the application of fair use to photographs among other different types of media. And why? Because we can do it. Because we create works, we share works, we access those works, we manipulate those works, we use those works in ways that were never possible before, or that certainly on a matter of scale or value never really made a difference to anybody. But it makes a difference today. And as a result, I think we're getting more of these cases because of that. And I highlight one case, a district court case, in which the court found that there was, in contrast, there was no fair use about the use of high school photographs of the new prince married into the royal family, princess married into the royal family of England. And so we have prince and princess, and there's Prince. And this gives us another transition. This is, by the way, if you haven't seen the Andy Warhol original, this is from the evidence that was used in the case. And this takes us to a transition to just some thoughts about music in general. You know, these are the cases that are getting the headlines and the attention. But we need to think about what they mean. Because we have cases about the blurred lines and what's the scope of copyrightability, the Katy Perry, the degree of similarity, the Stairway to Heaven, oh, makes me wonder, the protection of riffs and different sequences, and Happy Together, the Turtles, and their enforcement, they're spending money, somebody had to spend the money, enforcing, claiming their rights under state law for their pre-72 recordings. I think in general what these cases are telling us is that these are cases, again, about the way we create and use works, and these examples of music are very different from the way we could use it before, so we're getting the cases now. And the other thing that I think they're telling us is be careful about juries. You know, you put that case in front of a jury, you better ask yourself, what side am I on again? You know, because juries seem to be willing to identify similarity and pay a lot of money in return, somebody else's money. So these are, where they are as a matter of law, still, I think, haha, the jury's still out. You knew I was going to say that. And then Congress, and then the place of Congress. I want to highlight the Music Modernization Act, and I know others are going to be speaking to the licensing issues. So I'll look at that part of the Music Licensing Act and simply say this, that the Turtles, in litigating songs like Happy Together, and trying to figure out, is there even state law protection, and filing suits around the country, now Congress has reacted, and Congress has granted this quasi-copyright protection. It looks like copyright, it feels like copyright, it borrows from copyright, but it's technically not really copyright. Why? Because Congress said so. And it creates this new system only for pre-1972 recordings. And then finally, probably the most significant thing from Congress is what it did not do. It did not extend the term of copyright protection. When Congress last extended the term in 1998, we all sat back and put on our long-term calendar, will Congress extend it again as those works begin to enter the public domain 20 years later? And the answer is no, Congress did not extend it, which means on January 1st of 2019, we had another batch of works, published works from the 1920s, enter the public domain. And if Congress continues to not act, we will have each January 1st another wave of new works enter the public domain. Depends what side you're on, but this is extraordinary good news, it's extraordinary bad news. You have to tell me. You have to tell me. And with that, I say thank you very much, and I'm delighted to hand this over to Dave, who is going to tell us about trademark. Thank you.
Thanks, Katie. I think I'll stay at the table so that I don't block the screen. I'm a little taller than Kenny is, so I might. Sorry to point that out. So, I know this is now a copyright and trademark symposium. I'm pleased to see that. I've got a few minutes to talk to you about significant developments this year. Significant developments this year in trademark law. I'm going to cover two Supreme Court decisions that have an important impact for trademarks. We'll look at some cases to watch. Two of them are in the Supreme Court, and two or three of them are in other jurisdictions. I probably won't have time to go through others, but if you get the materials, you'll see a discussion of those cases there as well. If there's a theme this year, I think the theme is that in a number of these cases we're looking at, the decisions aren't really in trademark law. They involve other statutes, but the decisions have very important effects on trademark practitioners and brand owners. So this first case is an example of that. This is a case, Mission Products versus Technology, decided by the Supreme Court in May, that involved Section 365 of the Bankruptcy Code. The defendant in the Supreme Court, the respondent in the Supreme Court in Technology, was a trademark licensor. It licensed a mark to Mission Products, but Technology had financial difficulties. And before the end of the license, Technology applied for bankruptcy, and then under 365 of the Bankruptcy Code, asked the Bankruptcy Court for authorization to reject the license. Section 365A of the Bankruptcy Code allows a debtor, and sometimes will be a trustee, sometimes it's a debtor in possession, in Chapter 11 as in this case, to accept or reject any executory contract. An executory contract is one where neither party has completed performance under the contract. A trademark license, where one of the parties, the licensee, has the right to continue using the mark, the licensor has a continuing duty to monitor quality control, is an executory contract. So the Bankruptcy Court allowed the debtor, allowed Technology to reject that license, and Mission Products wanted to continue using the license mark. It was appealed to the bankruptcy appellate panel. And the bankruptcy appellate panel said that the license, although it was rejected, that the licensee could continue using the mark. And the court was relying on a decision from the Seventh Circuit that some courts have relied upon, the Sunbeam Products case, which said that licenses, trademark licenses, continue. But other circuits have found that when a trademark license is rejected, the right to use the mark ends. So in this case, Technology appealed to the First Circuit, and the First Circuit reversed the decision of the panel and said that the license was terminated. Now, in the Supreme Court, Technology argued, among other things, that there are certain exceptions that were created to the termination or the rejection of a license that would allow a licensee to continue or another contracting party to continue using the mark. For example, there's an exception that allows holders of certain real estate assets and timeshares to continue remaining in the property even after a contract's been terminated. And most significantly here, there's also an exception specifically for other kinds of IP licenses, like patent licenses, that allow the licensees to continue using the licensed IP asset. And Technology argued that this shows that Congress did not create that kind of exception for trademark licenses, and therefore the right to use the mark ends when the license is rejected. So in May, the Supreme Court rejected that in a decision by Justice Kagan. Justice Kagan and the court focused on the general language of 365, which says that if there is a rejection of the license, that constitutes a breach of contract. And they look to general contract law that holds that if there's a breach of a contract, that doesn't mean the breaching party has the right to rescind or end the contract. There are still obligations that continue. And the court concluded that that was the case with trademark licenses as well, so that when it was rejected, Mission Products had the right to continue using it. This has an important impact for trademark licenses. I've been involved in cases myself where I represented a party that was going to be a licensee, and they were entering into a license agreement with a licensor that had financial difficulties. And what we would do, particularly if the parties were in jurisdictions other than the Seventh Circuit, is try to put the trademark asset into a bankruptcy remote entity. The idea would be that if the licensor went into bankruptcy, hopefully the licensed trademark would continue to be owned by somebody else who wasn't in bankruptcy. That was never tested in any of our cases. Fortunately, we didn't have to go to that. And now that's not something we don't have to worry about anymore. So the next case is, here we go. So this is the next case. You can see probably what this case is about, just looking at the trademark that was being applied for here. This is also an opinion authored by Justice Kagan. This is the Brunetti case. Brunetti is an artist who told the courts that this mark was supposed to be pronounced F-U-C-T. Justice Kagan commented on that by saying, you might read it differently, and if so, you would hardly be alone. And so the question then became, under the Lanham Act, Section 2A of the Lanham Act, whether this was immoral or scandalous manner. The Lanham Act prohibits the registration of immoral or scandalous matter, and the examining attorney said that this was immoral or scandalous. And there are various factors that examining attorneys were directed by the Trademark Office to look at in deciding whether or not something is immoral and scandalous. The question was, would a substantial composite of the general public find the mark shocking to the sense of truth, decency, or propriety? Would they find it giving offense to the conscience or moral feelings? Would they find it calling out for condemnation, or is it disgraceful, offensive, disreputable, or vulgar? The TTAB concluded that under those standards, this mark was highly offensive, vulgar, and had decidedly negative sexual connotations. And the TTAB wrote, whether one considers the mark as a sexual term or finds that Brunetti has used the mark in the context of extreme misogyny, nihilism, or violence, we have no question that the term is extremely offensive. So Brunetti, the applicant, appealed to the Federal Circuit, which reversed and said that this provision was a violation of the First Amendment. So the Supreme Court agreed with the Federal Circuit that this provision violated the First Amendment. The rejected marks, in the court's view, expressed opinions. They looked at this mark and other examples of marks that were rejected based on the immoral and scandalous provision, and that they were at least offensive to many Americans, and concluded that the refusal to register these marks was not viewpoint neutral. And the court wrote, on its face, the statute distinguishes between two opposed sets of ideas, those aligned with conventional moral standards and those hostile to them, those including inducing societal nods of approval and those provoking offense and condemnation. Now, this is the second time in the last 2 years that the Supreme Court has addressed whether portions of Section 2A of the Lanham Act are unconstitutional. You may remember the Tam case, which involved a rock band that sought to register the mark slants, which has been recognized as offensive to Asian Americans. The members of the band were Asian Americans, and they said that by registering that domain name and using that name for their band, that they were trying to reclaim the term and drain it of its denigrating force. Now, the provision that was issued there, which was similar to the immoral and scandalous provision, was one that prohibited registration of marks that disparage or bring into contempt or disrepute any persons, living or dead. The court concluded that trademark registration is not government speech. It's not a government program subsidy such that the First Amendment wouldn't apply in that context. It's not commercial speech, and even if it was, it didn't satisfy the requirements for commercial speech in avoiding First Amendment issues. And the court said that if the trademark registration bar is viewpoint-based, then it's unconstitutional, and that was viewpoint-based. So the disparagement clause was declared unconstitutional, and it's not at all surprising then that the court this year found the same with respect to the immoral and scandalous provision. Okay, the next case is one that's before the Supreme Court, but it hasn't yet been decided. This is another example of a case that involves a different statute. This involves the Patent Act, but it involves a provision that's very similar to a trademark provision, and there's been a circuit court decision on that similar provision that addresses the issue. So in this case, NantQuest was the assignee of a patent, and they had applied for issuance of that patent, and it was rejected as obvious. They appealed to the Patent Trial and Appeal Board in the trademark office, or on the trademark side, that would be the Trademark Trial and Appeal Board. They appealed to the Patent Trial and Appeal Board. It found the patent, or the application to be, the invention to be obvious, rather, and then it was appealed again. And the question was, where were they going to appeal it? In most decisions of the PTAB or the TTAB, the applicant will appeal to the Federal Circuit. But if they want to develop more evidence, they can appeal to the district court instead, and that gives them the opportunity to do more discovery. If they didn't have survey evidence in a trademark case, they can try to develop that kind of evidence. But the Patent Act provides that an applicant that appeals to the district court has to pay the expenses of the PTO, whether or not they win in the case. And the PTO has recently been taking the position that expenses includes the prorated value of the salaries of attorneys and paralegals in the patent office that work on the matter, if they do work on the matter. So the Supreme Court is now considering this question, specifically whether the expenses of the proceedings encompasses personnel expenses of the USPTO when its employees, like attorneys, defend the action in the district court. So at the heart of this case is the operation of the American rule relating to attorney's fees. The basic American rule is that each litigant pays its own fees, win or lose in the case. And the Supreme Court has said in a number of cases that the American rule will presumptively apply in cases unless Congress has adopted a statutory deviation that is specific and explicit that attorney's fees need to be shifted from each party. So then how did the NantQuest case get here? In NantQuest, the PTO moved for reimbursement of its expenses, and that was about $80,000 in attorney's fees. The district court denied the motion, but the PTO appealed to the Federal Circuit. The panel reversed, and the Federal Circuit concluded that, initially the panel concluded that expenses does not include attorney's fees, but then
en banc, the Federal Circuit looked at it again and concluded that expenses do include attorney's fees. So the statute awards all the expenses of the action, cannot supply, according to the Federal Circuit, a specific and explicit directive from Congress to shift attorney's fees. So as I said, we've got the same issue in trademark cases. This is the provision in the Lanham Act that provides for payment of expenses if an applicant appeals to the district court. And the Fourth Circuit has addressed this question twice in trademark cases. The first was in 2015 in a case called Shamus. There, the court held that expenses does include attorney's fees. Another court in the Fourth Circuit looked at it again this year, Booking.com. I'll talk a little bit about that case later if we have time. It also deals with genericness. But Booking.com recognized the Federal Circuit called into question whether or not expenses includes attorney's fees. But Booking.com, in that case, the court concluded that they needed to follow the precedent of the Fourth Circuit. So this is the issue that the circuit split that the court is going to address now. And obviously, this has important consequences for applicants who want to appeal to the district court in order to develop a more extensive record if necessary, because if they're going to be paying not only their own attorney's fees, but the attorney's fees of the Patent and Trademark Office, that could have an impact on the ability of some to go forward. This is the second case that's pending now in the Supreme Court. This is under the Lanham Act. This is the Romag versus Fossil case, and this involves the question of whether or not willfulness is required for an award of profits. In this case, Romag sold some fasteners that were used on purses. Fossil had an arrangement with Romag that they would use their fasteners. Romag then discovered that there were counterfeit Romag fasteners being used on those products. There was a jury trial, and following that jury trial, the jury, in an advisory verdict, recommended to the court $6.7 million in profits, disgorgement of profits, as a deterrent for this behavior. But the jury also found that the behavior of Fossil was not willful, that they weren't aware that suppliers to them were using counterfeit materials. The district court held that Romag was not entitled to profits because the conduct was not willful, and Romag appealed to the Federal Circuit. They're applying Second Circuit law because it was in the Federal Circuit, it was a patent case, but there was also a trademark element, and so that's decided by the law of a regional circuit. So now this case is in the Supreme Court, and the question is whether willfulness is required for an award of profits under the Lanham Act. So Section 35A of the Lanham Act is the source of the issue. It provides that prevailing plaintiffs may recover a defendant's profits, any damages of the plaintiff, and costs. And there's no reference there to a requirement that there be any willfulness. It just states that any monetary relief is subject to principles of equity to be exercised by the court. So this language applies to all claims that will be brought under the Lanham Act, including claims for infringement or claims from cyber squatting. But there is an exception specifically stated in Section 35A, and that is the reference to Section 1125C. That's the Dilution Act. In order to recover monetary relief for a violation of the Dilution Act, the dilution has to be willful. So what did the Federal Circuit do with this case when it came to it? It followed the Second Circuit precedent, which requires willfulness. And what is the reason for requiring willfulness for recovery of profits? The idea is that disgorgement of profits is going to be a more draconian remedy than recovery of the plaintiff's damages. And also, the court recognized that the Dilution Amendment, which referred specifically to willfulness, corrected a drafting error and did not reflect the intent of Congress to provide that it needs to be clear that for any claim, willfulness is not a requirement other than for dilution. So there's clearly a split in the circuits that the court's going to be resolving now. 5 circuits require willfulness for profits, including the 10th Circuit. 1 requires willfulness if the parties are not direct competitors. And 6 treat willfulness as just one of those factors a court should look at in deciding under principles of equity whether or not there should be monetary relief. The 2 other cases I want to cover quickly are not in the Supreme Court. One is a case involving trade dress and secondary meaning. This is a case between Converse and And, well, it involved a number of other manufacturers like Skechers, but it's a case that's in the International Trade Commission, the ITC. As you may know, trademark issues like patent issues can be addressed in the ITC, and you get the main relief there is an exclusion order. So in this case, the issue is whether Converse was able to show that there was secondary meaning in its trademark, in its trade dress, and the trade dress is shown here. It's the combination of the lines on the side of what's commonly referred to as Chuck Taylor shoes, all-star shoes, the combination of the rubber toe and the two lines on the sole. Is there secondary meaning or acquired distinctiveness in that trade dress? Converse needed to show that there was secondary meaning at 2 points. First, when the first infringers started infringing, and that was sometime before 2013, and then also when this trade dress was registered in the Patent and Trademark Office, and that was in 2013. So the focus of the case has been, have they made the adequate showing? This is just a little chart for those of you who don't deal with trademarks, just to show where a descriptive mark fits in protectability. The marks at the top, arbitrary suggestive marks, are inherently distinctive. You don't have to show secondary meaning, which is referring to a consumer recognition in the relevant public that the term is a source identifier for single source. Then there are descriptive terms, which can be protectable, but you have to show there's secondary meaning or acquired distinctiveness. And then there are generic terms, which can never be protectable. So the issue here is whether or not that trade dress is protectable because there's secondary meaning. And with trade dress product configuration, it falls into this descriptive area because the Supreme Court has said that in order for trade dress that is the configuration of a product rather than packaging, you have to show that there's secondary meaning for that product. So the ITC found that the mark was invalid because there wasn't secondary meaning. The Federal Circuit reversed and then remanded to the ITC and made a few important points. First, Converse had argued that the 2013 registration, which provided a presumption that the mark was valid, meaning there's secondary meaning, that presumption applied not just to infringements that occurred after the registration, but also infringements prior to the time of the registration. The court rejected that, and on remand, Converse is going to have to show that there was secondary meaning in its common law rights in that mark at the time of the first infringement. The court also clarified what the factors are that the ITC should look to in deciding whether or not there is secondary meaning. And really the focus of all of these is what is in the minds of consumers as of the relevant time date when they see the mark. Do they think of it as an identification of source, or do they think of it as a description of a product? And the last case I'd like to touch on is one that also is not a trademark case, but it involves trademark issues. It's a case that was between 1-800-CONTACTS and the FTC. This is pending in the Second Circuit now. It has potentially serious consequences for not just brand owners, but also for defendants in trademark matters, because it goes to the question of whether settlements can be undone later because of potential antitrust violations. So in this case, as many of you probably know, 1-800-CONTACTS has been fairly active over the years in enforcing its rights on the internet and specifically in connection with keyword advertising. This case focused on 13 settlements that 1-800-CONTACTS entered into with a number of defendants between 2004 and 2013. The FTC did an investigation and concluded that these settlements were an unlawful restraint of trade under Section 5 of the FTC Act, and they focused on what the settlements did. They prohibited any bidding on 1-800-CONTACTS as a keyword, and they also prohibited or required rather negative keywords, which would have the effect of causing the defendant's ad not to appear if somebody ran a search on 1-800-CONTACTS, even where the defendant hadn't bid or caused the ad to appear. 1-800 Contacts argued that there were pro-competitive justifications for these settlements. They included avoiding the significant cost of litigation and then also protecting trademark rights. The FTC disagreed with that, said that these objectives could have been achieved with less restrictive means. For example, rather than prohibiting any bidding on keywords, the settlements could have required that when an ad appears, there be explanatory text identifying who the party was placing the ad, making it clear that the party placing the ad was not the company whose mark was bid on as a keyword. There are a number of issues with this, and in fact, there's been a number of amicus briefs, including by AIPLA. First, it raises the possibility that settlements will be reviewed and undone years later. It could discourage settlements in cases where there might be some questions about whether or not the law is established yet. And in fact, on this issue, I litigated a number of these keyword advertising cases for a search engine over the years where they would have been in the position of defendants. And what I knew throughout this period is that the law was evolving. And it took a while for courts to conclude that simply bidding on a trademark in and of itself was not trademark infringement. But that wasn't clear when these earlier settlements were entered into, and the FTC looked to that to take the position, I think unfairly, that 1-800 Contacts was taking a position that was unreasonable under the law at that time. So what the FTC has done raises the possibility that in hindsight, the FTC is going to go back and take a look at the law that, with a view that is the view that the parties to the case have at the time. And really, the parties who are in the best place to decide whether or not a settlement makes sense are the parties to that case. So these are the kinds of arguments that are being raised about the FTC decision. I won't try to predict what the Second Circuit will do with it, but this could have important consequences for trademark owners and defendants alike. So I think I've gone long enough. I'll stop with those cases, and we can open it up to questions on both sessions. Thank you.